Good afternoon, everyone, and thank you for attending the meeting of this licensing panel on Tuesday, the 9th of January. Before we make a start, I'd like to run through some housekeeping rules and some health and safety rules. So there are no planned fire alarms. If the alarm sounds, please leave by the emergency exits, the doors behind me, and you can go either way towards the emergency exits. If you do need the toilet at all during the meeting, please obviously through the doors, turn right, and the toilets are facing you there as well. Can I please ask that all mobile phones are either turned silent or turned off for this meeting? That would be very kind. Also, the meeting is being live streamed on YouTube, so any members of the public may wish to watch, they can do. So you can ask all parties to please use the microphone system when speaking. You'll find a button in front of you that says speak. When I bring you in, if you could press that, your microphone will go red like mine and you'll be able to speak. Thank you. I'll now ask all parties present today to introduce themselves. My name's Councillor Paul Wharton-Hardman and I am the chair of this panel. I'll ask my fellow colleagues to introduce themselves. Thank you.
My name's Hilary Bedford. I'm a councillor and a member of this panel.
Councillor Matthew Forshaw, member of the panel.
Thank you. And if I ask the licensing officer to introduce himself, please.
Yeah, no, my name is Justin Alberts, licensing officer at Southfield Borough Council.
Good afternoon. My name is Tasneem Safdar. I'm the legal advisor to the committee today.
Ruth Remington, Democratic Services.
Thank you. If I can now ask the applicant for review to please introduce himself.
Yes, I'm Chris Ward. I'm part of the licensing authority. Thank you.
Thank you. And the representatives of the responsible authority, starting with the police.
PC Connolly, Police Licensing.
Yeah, Immigration Officer Rice, representing North West Immigration Team.
That's brilliant. Thank you. And if I can finally ask the licence holder and the representative to please introduce themselves.
Yes, good afternoon, Chair. I'm David Dadds. I'm counsel and I'm representing the premise licence holder.
Good afternoon, Chair. My name is Vinay Javijakum. I'm interpreter.
Hello, I'm Mark Antoningrasa, premise license holder.
Thank you.
Thanks.
Could I actually just thank you very much. Thank you. We've also got other council officers in the building at present in the room. So I'll now outline the hearing procedure, which will be as follows. I'll go through it as we go through, so you don't need to remember any of this, but just for your information. So we'll start with the licensing officer outlining the application and any relevant representations. There will be questions to our licensing officer for clarification permitted from the committee members, the applicant, responsible authorities and the licence holder. The applicant, Mr. Ward, will then be invited to make representations in support of his application. There'll be questions to the applicant permitted from the committee, responsible authorities and the licence holder. Next, we'll hear representatives from the responsible authorities. We'll begin with the Immigration Authority and then we'll hear the police representations. Again, we'll take questions in turn for each responsible authority. The licence holder and his representative will be invited to make representations. Questions can be put to him again from the committee, the applicant and responsible authorities. I'll then invite each individual party to sum up as appropriate. Following that, all parties and officers who are not directly supporting the committee will be excluded from the meeting at this point, and the committee will enter deliberations. So that will be the committee, the legal services team leader and the democratic officer will remain for the deliberations, following which it's usually custom for this council to issue a detailed decision notice within 5 working days after this hearing. However, I am permitting today, if all parties or any party wishes to remain, you may do so, and following the deliberations, I'm happy to give an immediate answer today following the deliberations. Again, if any party wishes to leave and doesn't wish to stay for the deliberations, they could take 10 minutes, 15 minutes, an hour, 2 hours. We don't know. It depends what we hear today. You're more than welcome to receive a telephone call from our democratic services following the end of those deliberations. After which, of course, a detailed decision notice within 5 working days will be issued, and if any party isn't satisfied with the decision, they have the right of appeal to the Magistrates' Court within 21 days. Okay, right, I'll begin with apologies for absence. Have we received any apologies, please?
From Councillor Jane Bell. Thanks, Chair.
Thank you. Members' declaration of interest. Does any members have any interest to declare? Okay, thank you. I've outlined the procedure. We'll now begin with the premises licence review. Can I please ask our licensing officer, Justin Abbots, to briefly outline the application?
Thank you, Chair. The application before you today is for review of a premises licence made under Section 51 of the Licensing Act. It's for the premises Best One of Popular Avenue in Bamber Bridge. The premises is licensed for consumption of alcohol off the premises. The holder of the premises licence, please excuse my pronunciation here, is Markandu Lingasara, okay, who is the premises licence holder and additionally the premises supervisor. Mr. Lingasara has been the licence holder since January 2023, when the licence was transferred into his name. Yep. The application for review has been sought by the licensing manager, Chris Ward, on behalf of the licensing authority on the grounds that the licensing objectives have been undermined and not promoting related to crime and disorder. Details of the grounds of the review can be found in the application form and attached to the report as Appendix A. Mr. Ward will provide further information regarding his application later in the hearing. The review application was served to all responsible authorities and notices were placed at the premises and on the council's website in accordance with the relevant regulations. Subsequently, 2 supporting representations have been received. The first one being PC Stephen Conley on behalf of Lancashire Constabulary, who has submitted a supporting representation that also states the licensing objectives protecting children from harm has also been undermined at the premises following a failed test purchase for the sale of knives at the premises. And the second representation is Sean Wright from the immigration officer on behalf of the Immigration Service, who has also served a supporting representation of the review of the licence on the ground of crime and disorder on the grounds of the premises licence holder employing illegal workers on the premises. Details of the supporting representations can be found in the attached report, Appendix B and C. Both officers will provide further information regarding his review application later in this hearing. Members of the panel are asked to consider all evidence put before them today from all parties and consider the options available. The options are revocation of the licence, suspension of the licence for no more than 3 months, add or remove conditions to the licence, remove a licensable activity, remove the DPS, or take no action. Thank you very much, Chair.
Thank you. Do we have any questions to the licensing officer from any members of the panel? Do we have any questions to the licensing officer from any of the applicants or responsible authorities? No. Of course, Blinky.
So could I actually make, Chair, I don't wish to cause a fuss, but is it possible that the applicant and Councillor Forshaw, that they are not so close together? I think there should be a separation between the tribunal making its decision and the applicant. I think it's probably just better that it's seen to be separate. No disrespect to you, Councillor. I know that you will do things separately, but I think from a public perception point of view and the premise licence holder point of view, there should be a separation. And then I do have some questions for the officer, if that's all right.
Of course, yeah. Thank you. Points noted. Could I ask the applicants and the responsible officers to go and sit on the back? Is that okay? Do you want to take your name card with you? Does IT need any time to adjust and set up those microphones as appropriate? Thank you. We'll just wait for them to move and then I'll go to your questions. Thank you. I'll just get confirmation from IT before we continue. Obviously, this is live streamed and I'll need to make sure that the cameras and microphones are working as appropriate. So if you want to just quickly get that sorted, we can go from there. Is that okay? Fantastic. Thank you.
Thank you, Chair. As I say, it's no reflection on anyone here, but I think it's probably best because in case they see each other's notes or, it's just better in that way. Could I possibly, through you, Chair, ask the presenting licensing officer, you've got in your report, say at paragraph 15, so it's page 6, it says, because following this, the business owner will serve with illegal working civil penalty notice. In other paragraphs, you refer to it as a fine. Can we just clarify, wherever it says fine, you mean a civil penalty? That's the first question.
Through you, Chair, I cannot answer this question. I have had no involvement with this this case at all, so I would not be able to answer your question, unfortunately.
Chair, perhaps it's a question that the immigration officer can deal with, maybe at a later point in terms of the actual civil penalty or the fine. Is that okay with you, Dad?
Yes, well, I will address it as a matter of law, but I thought that given the officer had presented the report, I appreciate now that he's not the author of the report, but so perhaps it won't be that helpful for me to go through the report if he's not able to speak to it. But I'll point out a number of points. Lastly, actually, in relation to the order of steps that the committee can take, you've set that out in paragraph 25, page 7. So make no change, modify, exclude, remove, suspend and revoke. Can you see the order that it takes through? But I'm just conscious that when you spoke, you did the reverse order. You said they could revoke the license and then went through the reverse. It is always this order: make no change, modify, exclude, remove, suspend, revoke. It's not the reverse. It's only that when you spoke, you did it the reverse. And I just wanted to check that we should always be looking at an appropriate and proportionate response and doing the least thing first. And only if you don't think that step is not necessary, you then move to the next step. Thank you.
Sorry. Through you, Chair, I think that I can say that obviously the panel are very experienced and understand that process. And they will take note of your comments.
Do you have any further questions? No, thank you. Okay, we've got no questions. Can I please ask Mr. Chris Ward to make his representations? We've also received additional information which is supplementary in the paper. Please obviously detail that as well if you do wish to. Thank you.
Thank you, Chair. So the application for the review has been brought by the licensing authority, and I've brought that on behalf of the licensing authority itself. On the 11th of March 2023, at approximately 17:30, attended the premises with immigration officers at the premises. Upon entering the premises, there was 2 males working at the premises. Male 1 identified himself to the immigration officers as the licence holder, Mr. Lingarasa. He was in charge of the premises at that point. Inquiries were made by immigration officers regarding a second male status, and after about 5 minutes, it had been revealed that that person didn't have rights to work in the UK. Whilst immigration officers continued their work in questioning that second person, a separate interview by the immigration officers took place by Mr. Lingarasa, which I observed, ready to discuss issue with the licence with Mr. Lingarasa following their interaction with him. Mr. Lingarasa was asked if the second male at the premises was working at the premises. Mr. Lingarasa denied that the male was working at the premises and stated he was just a friend who was visiting him. At the premises, there's multiple CCTV cameras within the premises. Mr. Lingarasa was asked by immigration officers to provide access to the shop's CCTV system. Mr. Lingarasa stated the CCTV system wasn't working. At this point, one of the immigration officers who was stood with me asked Mr. Lingarasa, well, why is one of the cameras got a green light illuminated on it behind the counter? To which Mr. Lingarasa replied once again, no, the CCTV isn't working. Following speaking with Mr. Lingarasa, walked to the back of the premises with a group of immigration officers to the storeroom. On inspecting the storeroom, the rear of the premises, we found that Mr. Lingarasa did in fact have an operational CCTV system. The system had a display screen and a hard drive system. The system was functioning and in operation. Immigration officers operated the system, pulled the footage back, which showed the person in question working behind the counter. In my opinion, Mr. Lingarasa had lied to officers and was trying to mislead us in obtaining evidence regarding the second person who was working. In the following weeks, the licensing team conducted a number of visits, looking at what age verification policy was in place at the premises. On the 9th of May, I attended the premises with a fellow licensing officer. We entered the premises and encountered a male behind the counter. We waited for him to finish serving his customers, introduced ourselves, provided our identities, and told him that we were from the licensing authority. We asked various questions, licensing related questions relating what training he received, what age related checks he performs. The male really had no idea what we were talking about, and his level of English skills were quite poor. The male was asked if he got any identification at the time and were presented with a residency permit. I asked if it was his ID, which we were advised yes it was. The residency permit stated skilled worker and restricted work. Following on from this, on the 19th of May 2023, I referred the information through to our contact immigration service, Sean Wright, who's here today. He was the officer in charge from the joint visit on March 2023, and he's here today on behalf of the immigration service. On the 12th of July 2023, officers from the immigration service conducted a second inspection of the premises for illegal workers, following information that had been passed through from the licensing team. 2 alleged illegal workers were found at the premises and arrested by immigration officers at the scene. One of the workers was the same male identified and referred to the immigration service by myself on the 9th of May. Reviewing the premises licence must be a relevant promotion to one or more of the licensing objectives. Under the prevention of crime and disorder includes the prevention of immigration crime and illegal working. In my opinion, lying to officers regarding the CCTV not being operational on the initial visit isn't an action of a licence holder promoting the licensing objective, prevention of crime and disorder. Being caught employing illegal workers, then continuing to employ multiple illegal workers with no rights to work, again for me, is not the action of a responsible licence holder that seeks to promote the licensing objectives, in particular, again, the prevention of crime and disorder. Given the seriousness of being caught employing an illegal worker initially in March 2023, you would expect a responsible licence holder to make sure this does not happen again. You would expect a level of due diligence from the licence holder previously caught employing illegal workers. You would expect a responsible licence holder to react following caught employing illegal workers and perform checks of all employees' right to work before they are employed. For this to happen a second time with 2 additional illegal workers found working at the premises, in my opinion, is unacceptable and is proof the licence holder has a disregard for the law. I ask members of the panel today to take seriously ask themselves, can the risk of further immigration crime sufficiently be mitigated by conditions being placed on the licence? Would the licence holder adhere to them? Would a suspension of the licence deter him from employing illegal workers again? The fact he'd received a large fine from the immigration service previously has not deterred him from employing illegal workers for a second time. So why should a suspension of the licence? The licensed premises based in South Ribble to be found in a position should cause this authority a huge concern, and I believe the premises has repeatedly traded irresponsibly. I refer members to the latest revision of the Licensing Act, Section 182 guidance, which states a serious, robust approach to illegal workers in licensed premises should be taken. In particular, the following sections: 11.23, which states, where premises are found to be trading irresponsibly, the licensing authority should not hesitate, where appropriate to do so, take tough action to tackle the problem at the premises. Where other measures are deemed insufficient, revoke the licence. 11.27, which states, there are certain criminal activity that may arise in connection with licensed premises which should be treated particularly seriously. These are the use of the licensed premises, and one of the options there is for employing a person who disqualified from work for reasons of their immigration status in the UK. And 11.28, it it is envisaged that licensing authorities, the police, Home Office, immigration enforcement and other law enforcement agencies which are responsible authorities will use the review procedures effectively and deter such activities of crime where reviews arise and the licensing authority determines that the crime prevention objective is being undermined through the premises being used for further crime. It's expected that revocation of the licence, even in the first instance, should seriously be considered. In my opinion, the revocation of the licence is necessary as the crime and disorder licence objective has been seriously undermined at this premises by the employment of legal workers on more than one occasion. Thank you.
Thank you. I'll open it up to questions from any members of the panel. Okay, any questions from any of the responsible authorities? Questions from the applicant's representative? Thank you.
Thank you. Officer, have you ever taken a review before in relation to alleged illegal working?
Not an illegal working one, no.
In relation to the sale of alcohol, I just want to ask some questions about that, if I may. The premises licence authorises the sale of alcohol. Can we just clarify, in relation to the papers that you've put before members, there's no offence under the Licensing Act at all? So there are no Licensing Act offences, is that right?
There's no licence of offence being mentioned, but there is breach condition. Breach of undermining the licensing objective is what we've targeted at. Thank you.
Yeah, so no licensing offences, no breach of conditions either, because there's only the mandatory conditions, no other conditions on the licence. That's correct, isn't it?
There's no conditions on the licence other than the mandatory conditions.
Yeah. So no breaches of conditions either. I'm conscious it's not cross-examination, but I need to just clarify these points, Chair. Thank you. In relation to, for example, underage sale to a under 18 for alcohol, can you just tell me, there's been some test purchase exercise, or certainly one, but there may have been many. Can you just tell me how many test purchase exercises have there been in the last 2 years?
Chair, I think that's a question directed to the police officer, the licensing officer in charge of the police.
Well, if I'm asking you the question, if you don't know, then that's fine. You can just answer it, and I'll ask the police questions later.
Yeah, I think that's for the police to answer. They've put the representation in protecting the children from harm, not myself. Thank you.
So you, from the licensing authority's point of view, you're not aware of any foul test purchase regarding under 18 relating to alcohol?
Not for alcohol, no.
And are you aware of any tests from the licensing authority's point of view regarding alcohol for underage?
Do you want to clarify what you mean by test?
Well, are you aware of any test purchase exercise from the licensing point of view regarding testing for the sale of alcohol? You're the licensing authority. One would assume that you will know, especially as the manager of licensing, whether this premises has been tested for example, whether alcohol has been attempted or not. I'm just wondering from your point of view if you know that that's been done or not.
Could I just clarify, is that in relation to this premises or generally across the borough? Thank you.
No, I'm only talking about this premises, sir. Thank you, Chair.
Yeah, in the representation received from the police, it does reference that there was a past alcohol test purchase following the underage knife test purchase exercise as well.
So you're aware that there was a test and it was successfully passed in relation to alcohol?
Following that, yes.
Yeah. Are you aware of the council's enforcement policy about a graduated approach to enforcement? I don't know if I have to keep on turning.
I am, as in a stepped approach, yes, yeah.
Can you tell me, please, in relation to visits and the concerns that you've raised? So, for example, you've raised concern about illegal working. You've not, so let's just deal with that first. Have you written to the premises, because you've called the review, have you written to the premises since last January and now to say, look, we've got concerns that you may be employing illegal workers. These are the steps that you need to take?
The premises licence holder has been written to by the Immigration Service themselves, so that's already been actioned. So he's aware that obviously the premises has been employing illegal workers at that point.
But I'm asking you from the licensing authority, because you're bringing the review, not immigration. Now, immigration normally bring these reviews. I'll make submissions on that later. But you're bringing it, and I'm asking you, have you written to the premises since January and now regarding educating, advising, in accordance with the graduated approach to enforcement, about your concerns about illegal workers? Have you done that, please?
Nothing's been put in writing, but we have had conversations with the licence holder following the visit in March.
And have you kept a record of any of your written notes regarding advice?
There was notes taken in March, yes. There was notes taken in March, yes.
But they're not in your papers, no?
I've not submitted that, no. No. Sorry, are you unable to hear me? Right, okay. Yeah, it's
It might be my hearing as well, because there's some other noise over here. Sorry, you're competing. And it might be the air conditioning. Sorry, it's probably me. Right, officer, in relation to the matter that you commented about the craft knife, are you aware that there was a warning given, and that's how the county council dealt with that issue, or trading standards?
I was aware of that when I was informed by the police, yes.
And you're aware that that was a warning given last June, and that there was a subsequent test of the premises in November where it was successfully passed, i.e. it was tested again, and no repeat of what occurred previously. You aware of that?
I was aware they passed the second test purchase, yes.
And can I just ask, in relation to training, any concerns that you've raised about training, refusal register, and training generally, have you written to the premises offering them some advice or any guidance regarding training of staff?
Well, as you mentioned before, it isn't a condition on the licence currently. That is something that we would look at depending on what the outcome of this review is. But yes, there does need to be some training at the premises.
The question was, had you written to the premises regarding your concerns raised today to members regarding training and the licensing objective? Had you written to the premise license holder and said, look, we visited, we felt that there may be a lack of understanding of the requirements under the Act. We would encourage you to do X, Y, Z. Did you write any type of letter like that at all since last May and now?
Not about training, no.
In relation to the second visit for the immigration, the 12th of July, you commented quite robustly, actually. You've said it's completely unacceptable, disregard to the law, breaking immigration offences, multiple occasions illegal, and they were fined. That was your language that I wrote down. Are you aware that there's a current appeal being challenged to that allegation? And also there's also a judicial review challenge at the moment in relation to that individual. Are you aware that actually that has not been settled yet as a matter of process?
I was made aware of that on Friday of last week by the Immigration Service, and the supplementary documents is what I submitted through to the Immigration Service following that they requested, which I've obviously made available for you to look at. Obviously, it's in circulation. Okay.
So just to clarify, you are aware at the moment that there's been not proven any crime as committed in July. Are you aware of that?
I'm aware of appeal by judicial review, yes, of that, yeah.
So at the moment there is no crime. Do you accept that?
I think that's more a question for the Immigration Service officer as well, isn't it? But as far as I'm concerned, as per the review document, he's been caught with an illegal worker in the premises. He's then appealed it afterwards by judicial review.
Mr. Chairman, I don't want to get into cross-examination. I'll make submissions, but I would like to explore a couple more questions around that subject, if I may.
I'm more than happy to. Thank you.
So, Officer, I know you say that that's a matter for immigration, and I will ask the officer that, and I know that members will probably do the same. But it's your comments to the committee today. You've said, I want the licence revoked. They've committed crime. Multiple occasions in July, employing illegal workers. But there's an allegation of illegal workers. There's a right to reply. They have replied to that allegation by way of an appeal. That appeal has got to be concluded yet. Isn't it right that there should be due process? You're innocent until proven guilty. You've made him feel guilty already today. You've tried him in front of all these committee members, and actually it's still under appeal. That's right, isn't it? So would you, can I invite you just to withdraw the allegation that he's committed a criminal act? You can say it may be alleged and it's part of an appeal process, but you can't be firm, can you, to say he's committed a criminal act?
I can refer that to change to the civil notice was issued, and that's now being appealed, yes.
Thank you. In relation to language, there's a problem with language. I think it's accepted that this language is not as fluent as you and I. And that when under pressure, the language, I would submit, reduces. In relation, you haven't made a note or reference. Are you aware, I think you are, because I think you've had conversation, are you aware that tobacco was seized at the premises?
The police seized tobacco, yes. Again, I think that needs to be directed at the police. I haven't got powers of seizure. The tobacco wasn't seized by myself.
And I just want to sort of understand you, if you have knowledge of this, is I think you've spoken to the premise licence holder about compensation because certain packets were opened and all that. Are you aware of any of that at all, or someone in your team?
Nothing to do with me, no. We haven't had that conversation. As far as I'm aware, no, I didn't know that any packets have been open. I'd imagine that's been gone through to trading standards, that they've investigated that.
You've called him a liar regarding the CCTV. Could it be that you've misunderstood him, or he has misunderstood you in relation to language? Because I think it's only right that I say this to you, so you give it an opportunity. I will make representation to the committee. He says he was asked about the CCTV, and he gives an answer. He can't recollect the detail, but in essence, the answer was, I don't know if it's working. And he directed you to where the CCTV was stored.
That's completely incorrect. he was asked twice by an immigration officer, where's the CCTV? He said the CCTV isn't working. We was then asked, why is there a green light on the camera behind? And his response was, the CCTV isn't working. The screen and the hard drive system was found by immigration officers in the back. They wasn't directed there whatsoever.
Can I ask, did you ask him the question? Did you speak to him? Is this hearsay from someone else?
No, I stood in the vicinity at the side of the immigration officer when that was asked. And I was waiting to speak to him, obviously about the licence and see if there was any licences.
But did you hear this conversation clearly? Both.
I heard it clear. I was stood within a metre of the person. The licence holder was stood behind the counter. We were both stood in front of the counter.
But do you accept that he may have misunderstood the question, or the answer he gave was misunderstood? Is there a possibility?
The reply was the CCTV isn't working.
Right. Well, I'll make submissions on that. Can I just ask a question about the CCTV? He doesn't actually have to have CCTV in the premises at all, does he? There's no condition.
Not conditioned on the licence, no.
So if he wanted to commit a criminal offence, he could actually just have no CCTV, switch it off if he wanted to.
That could be the case, yeah, he could turn it off. I would imagine he'd only took that premises over in January. The CCTV may well have already been in the premises when he's obtained that premises. But there was operational CCTV in place and he isn't conditioned to require that.
So do you not think it's normally premises operating lawfully, correctly, running CCTV, keeping recording of what's going on? Is that the normal conduct of someone that may be conducting illicit or illegal activity? Would you normally find a criminal or a liar, as you've put it, recording their activity on CCTV when they don't need to as a condition? Is that normal practice?
Well, I would say no. If someone's got CCTV, they're not covering up their own actions, no.
I don't have any more questions. I'll leave it to submission. Thank you.
Thank you. Can I just invite our legal representative to make comment? Thank you.
Thank you, Chair. Through you, I just want to make a point of clarification, if I may, and it's a relation to the point made around the crime aspect. So, I mean, in order for the actual crime prevention objective to be engaged, it's not necessary for a crime to have been reported, prosecuted, or established. So I just wanted to make, and I think the point that you were making was around the prosecution of, the illegal activity. So I just wanted to point out that it's not, and this is the case of East Lindsey Council versus Hanif, which I think you were involved in as well. Wasn't it the point that was raised and the court sided with you as well? So I think I just wanted to say, in order for the crime objective to be engaged, the crime prevention objective to be engaged, it's not necessary for the actual crime to have been prosecuted. Thank you.
Can I just respond to the advice? Would you mind? It is right that's East Lindsey District Council and ANIF, and it was in the High Court. And I, along with Philip Colvin, did that. I did it at the first instance with the local authority, and then did it, and then undertook it with Philip Colvin at the High Court. I think there may be a misunderstanding in the submissions I make. I'm challenging this officer because this officer is saying a crime has been committed, and I'm saying that it hasn't. You're innocent until proven guilty, and that's the difference. He can argue that there may be a civil penalty being issued, but that's subject to an appeal as well. And under the Immigration Act, for an offence to be proven in court, you have to show knowledge. And that's not been prosecuted. Now, it's not going to be prosecuted. We don't have to wait for that because the civil penalty has already been issued. So therefore, there is no prosecution and there's no crime. So there's a difference between the two. And I'm making it quite clear. With ANIF, it's about a review should be brought down. The burden is on the applicant. They have to show that the licensing objective is undermined. If the officer is saying that there was a crime on the July matter, then it's for him to prove. He or cert must prove. He can't prove that. and I was challenging that by me asking some questions, and I will make submissions. But certainly you'll hear from me about this further as we go along today, I'm sure. Thank you.
Just wanted to point out that in terms of the clarification point, just so that members are aware.
Thank you. Okay, I'll please now invite Mr. Sean Wright, Immigration Officer, to make his representation. Thank you.
Yeah, my name's Sean Wright, Immigration Officer for the North West Enforcement Team. On the 11th of March 2023, I was the officer in charge for an immigration enforcement visit to Best One Bamber Bridge based on intelligence received. On this occasion, one person without permission to work was encountered. The individual was an overstayer in the UK, which is an offence under Section 24C1 of the Immigration Act 1971 as amended. The individual encountered had no outstanding applications and no permission to work. His employment was confirmed with CCTV footage over an extended period of time. The business was served with a notice to issue a fine for employing an illegal worker on this date. The notice contained information on how to obtain guidance on preventing illegal working. The business was issued a fine by the Home Office Civil Penalty Team on the 20th of June 2023 in relation to a breach of civil penalty under Section 15 Immigration, Asylum and Nationality Act 2006. The business paid a £10,000 fine in full for employing one illegal worker. On the 12th of January 2023, my colleague Immigration Officer O'Brien was in charge for an immigration enforcement visit to the same premises. Based on information received from our colleagues in the council, that an individual without permission to work was encountered at the premises by them in May. On this occasion, two persons with no permission to work were encountered working within the premises and the business. One person attempted to leave at the rear of the business. One individual had an outstanding asylum claim and therefore had no permission to work. The other individual, who was also encountered in May by our colleagues in the council, had valid leave to remain in the United Kingdom, however had no permission to work in the place that they were encountered. They were only entitled to work in the care worker industry. The business was served with a second notice to issue a fine for employing illegal workers on the 12th of July 2023. The civil penalty team has a high threshold for issuing a fine in which three factors have to be met: remuneration, control and obligation. A fine has failed to deter the licence holder from employing a suspected illegal worker, and they appear to have failed to conduct any simple right-to-work checks. On the 2nd of August 2023, the business was issued a fine by the Home Office Civil Penalty Team for £15,000. This, however, has not been paid and appealed. This is in respect of the male whom was identified by our colleagues in the council back in May. We are therefore seeking to support the licence revocation under the Crime and Disorder Act.
Thank you. I'll now ask, are there any questions from any of the panel members? Any questions from the applicant? Any questions from the police? Any questions from yourself? Thank you.
Good afternoon, officer. Just a few questions, if I may. Can we just clarify a couple of the points, especially around the language, if you don't mind? It's not a fine, it's a civil penalty. I'll go into what the difference is later, but do you accept it's a civil penalty, not a fine by the court?
All I know, the title is called Civil Penalty Fine. I don't know the actual why it's called a fine, why it's not called a fine.
But do you accept it's a civil penalty that they are given? It's not a fine.
Yeah, so I'll admit I don't work for the civil penalty team. I don't know the difference between a civil penalty and a fine. As far as I'm aware, we call it a civil penalty fine. I wouldn't know the difference, unfortunately.
Okay. Well, hopefully this afternoon, I'm not being rude, but you might hear the difference. There is a difference, officer. In relation to the civil penalty that was issued for July, that's been subject to an appeal, and there's appeal process. Is that correct? Right.
Yes, that's correct.
And in relation to the CCTV, I'm just going to concentrate for the moment. I'll shift to the other one in a moment, but the July inspection, 12th of July. CCTV was looked at. Did you look at the CCTV yourself to see that they weren't actually working? They were in the storeroom.
I wasn't on the visit in July. I was on the visit in March. I have not been given any feedback about CCTV footage from July.
Yes, but CCTV was available and was looked at by the officer that day.
In respect of July or March?
July.
I'm not aware, sorry.
All right, okay. Are you aware also in relation to the July visit, the individual is, or there is proceedings in the High Court for judicial review?
Yeah, I'm aware of this, and because of the fact that he was also encountered by our colleagues in May, we do strongly suspect that he was working there from May to July.
But you're aware of the judicial review for that. Are you also aware that the individual is a family member, a cousin of the premise licence holder? No. Now, in relation to the visit for January, was you the officer asking questions about the CCTV? Sorry, March visit, yes.
I wasn't the officer, no.
Is the officer here that for that?
No, but like Chris, I was standing basically next to the officer at the time.
Was you, could there have been any misunderstanding from your point of view, or certainly knowing his language, that he's saying, I'm not sure if it's working, to words to that effect?
Like my colleague also heard, I significantly heard that he said the CCTV is not working.
Officer, in relation to the civil penalty, it's normally issued for 20,000, is that right?
Yes, so it's up to £20,000. Normally with a first-time offence, it's reduced, or if you respond within a certain time scale, for example, there's many factors that mitigate the reduction.
Yes. So just so that members are aware, the penalty would normally be 20,000, but if you cooperate, or if it's your first time, or you've taken some steps, they reduce it down from 20 to 15 and possibly 15 down to 10. Is that right?
As far as I'm aware, yes.
So in this case, a penalty notice of 10,000 was given because he'd cooperated, provided information, and the first time, so therefore they gave him a penalty of 10. Is that right?
So without having never worked for the team itself, I would suspect that it's because it's the first time offence. I wouldn't be able to, I'd just be speculating otherwise.
And in relation, you said that he had paid 10,000, but in fact he had paid 7. Is that right? Because if you pay within a certain time, it's reduced further.
Yeah, again, I'm not aware of that. Again, I don't work for that team, so I don't have full access to their records.
But you've said to the committee today, I'm just a bit concerned that you, as well as the other officer that's spoken, are making assertions and then saying, well, actually, I'm not sure of that. I don't work for that team. No different to the officer this morning with the report saying, I've spoken to the report, but I can't answer any questions. You have said he was fined £10,000 and he paid £10,000. But I'm saying to you, actually, he was given a civil penalty. It was reduced as discount and he paid 7. So you said what you said earlier on was not correct, was it?
Okay, so the information I received was that he paid the £10,000 fine in full. And ultimately, he has received the fine for illegal work and paid it. So there's nothing really I can add to that.
Now, the civil penalty is given because the employer has failed to do the relevant right to work checks. That's right, isn't it?
It's that, and together the fact that the guy working there had no permission to work.
Yes, but there's a difference. If you have knowledge and you've illegally employed someone, you can commit a criminal offence. Do you agree? in relation to civil penalty, you don't have to prove knowledge. It is a civil penalty to say you as an employer need to check documents. If you don't check documents, we can give you a civil penalty. That's different, isn't it? Okay, I'll make submissions on that.
Thank you. Okay, can I please now ask PC Connolly to make representations from Lancashire Constabulary? Thank you.
Good afternoon, Chair. My representations today are somewhat briefer than what they would normally be, so there won't be much speaking for myself. I'm not going to go into detail of the description of the premises. I've put it in my report, so it paints that picture for all parties there. If it's okay with yourselves, I'm not going to read my report verbatim. It's there, and I will just surmise some of the more key points. So, police involvement with the premises began on the 9th of January 2023. That's when a colleague of mine attended the premises unannounced to speak to the licence holder following the transfer and variation to DPS. It's a fairly standard process for us. We would refer to it as a DPS interview, just to make sure that everything is kosher with an applicant, that the premises is trading safely. Where possible, we'll offer advice and guidance. On that occasion, the licence holder was not present, and my colleague, and for clarity, my colleague has since retired from the police. So it is limited. I've only got her notes, unfortunately. Spoke to the licence holder on the telephone after speaking to two members of staff inside the premises, and arranged to see him. My colleague was concerned about the two members of staff inside the premises. They spoke very little English, and one of them was described as being quite evasive around providing any information of who they were, denied working at the shop, and had visited and was a friend visiting from another shop. They recorded that and arranged to reattend the premises a couple of days later. My colleague reattended on the 11th and met the licence holder, went through the various bits and pieces, had no real concerns at that time. The licence holder showed her a signed authority to sell form and talked her through the Check 25 training that he has in place, as well as talked through refusals register. The licence holder was advised at that point that a test purchase was to be carried out. What I have just missed from the previous submission on the 9th was my colleague was concerned around these two males and reported to immigration that she had concerns over the evasiveness of these males. That is all I can say as to why she reported it. It just a bit of a gut feeling, effectively, that made her suspicious. For clarity, it's not in her report, but she had 10 years working within police licensing, visiting quite literally hundreds of licensed premises across the borough in that time. And she'd built up quite a good network of contacts. So that's why that referral went in. My first involvement was on the 11th of March 2023. I was originally due to attend with Mr. Ward and immigration for a multi-agency inspection of the premises. Fortunately, I got tied up with something else, and it meant that I arrived somewhat later to the premises. I was made aware that there was a member of staff that did not have the right to work at the premises, but I had no involvement with that side of things. What I did have, and I've not put it in my report, but Mr. Dads has already mentioned it, and it's about the seizure of some tobacco products. When I've arrived at the premises, there have been concerns raised over some tobacco items that were in the storage area of the premises. I'm not trained to be able to verify 100% that some of it is counterfeit tobacco. I work closely with Lancashire Trading Standards and other partners, so I generally get a feel for when something's not quite right with these particular items. And the storeroom in particular, you go through the back and it's just on the right. It's a lockable door. In that room, there was a filing cabinet that was locked. Inside there was quite a well-organised tobacco storage system. I think it was in either brand order or alphabetical order, something like that. But on that table, there was just 3 black bin bags filled with tobacco products. I asked the licence holder that night where they come from. and all he could advise me was a cash and carry in Liverpool. Couldn't tell me where it was, had no invoices or anything like that. I was concerned that that tobacco may not be legitimate. So I advised him that it was going to be seized. I was lawful on the premises, so it was seized under Section 19 of PACE. Explained to him that I'm not an expert and I would get Lancashire Trading Standards to quickly look at it to see if they could verify it, and that if it was all in order, it would be returned as soon as possible to him. That happened within a couple of days. Lancashire Trading Standards did come to my office. They inspected it, but on their initial inspection, it was inconclusive. They could not determine whether they were genuine tobacco products or counterfeit. They then decided to take items from each of the packs, send off for testing. They did later come back as genuine. There was no further involvement at that time until the 18th of April 2023. And that's when the tobacco was returned to the licence holder. He wasn't present at that time, but they were returned to a member of staff. On that particular occasion, Lancashire Trading Standards came with us. I was also with Mr. Ward from South Ribble Borough Council, carried out an inspection. There was a member of staff that had restricted work, but it wasn't relevant towards that particular field. I believe it was that he wasn't to participate in sporting employment or something along them lines. There was an old packet of cigarettes that were found at the bottom of one of the displays. It was a standalone packet. It was deemed to be left over from a previous owner or discontinued stock, and that item was taken away by Trading Standards. Did speak to the member of staff regarding the sale of alcohol and other age-restricted items. The member of staff claimed that he'd not been trained in any way, shape or form. On the 19th of May, the premises was subject to a multi-agency test purchase operation for the sale of knives. It's a national campaign as part of Operation Sceptre that's dedicated to tackle knife crime within our communities. During the initiative, the premises failed and sold a trimming knife to children aged 13 and 14 years old. By trimming knife, I've always known them as a Stanley knife. Effectively, it's a plastic extendable blade, very thin, and the blade effectively locks in place and is used for carving. Lancashire Trading Standards issued a warning following that. So after the initial failure, Lancashire Trading Standards went to speak to the staff, gave some information around age-related sales there and then the premises was written to a short while after that. I believe that was in June. On the 2nd of June 2023, I'd arranged to do some alcohol test purchasing within the borough. Because of the failure for the knife test purchase, I felt that it was appropriate to visit the premises to check to ensure that they were upholding what they should be doing, and fortunately they passed that and did not sell alcohol. On the 12th of July, we received an email from immigration advising that a second worker without permission was located at the premises, and that there was a notice of intention to issue a fine up to £20,000 was served at the premises. And then on the 16th of November 2023, we did another knife test purchase under the Operation Sceptre, another multi-agency test purchase, and fortunately they passed on that occasion. Fortunately, they passed.
Thank you.
In terms of those multi-agency test purchases, Chair, obviously Trading Standards themselves are a responsible authority. Before my representations went in, I did have the discussion with Lancashire Trading Standards, and they felt that whilst they would support a review, they didn't see the purpose in presenting the exact same information that I would be doing about the knife test purchase. That's all the information they had. It was a joint initiative, so on that occasion, I decided that we would make that representation. Because my colleague had effectively started the immigration concerns, I felt that my representations were more appropriate on this occasion. So the sale of a knife to a child whilst it is not a licensing offence, knives are not a licensable activity, it is a criminal offence under section 141A of the Criminal Justice Act 1988. It's a criminal offence. It clearly undermines the prevention of crime disorder. The test purchased on that occasion were 13 and 14 years old children. Fortunately, it was a test purchase and it was not a genuine sale. It was controlled and those children didn't get that knife that went into the authorities' hands. But it also undermines protection of children from harm. Effectively, my outcome is to support Mr. Ward in his application today, and that is to support his request to revoke the premises licence. I could start quoting the Section 182 guidance, but Mr. Ward has already covered them, and I would just be duplicating what he has already said. But in terms of the outcomes, you could choose to do nothing. You could remove the DPS. However, the DPS is the licence holder. I feel as though that would have little effect because he still has that overall control of the premises. Applying conditions. Section 116 of these 182 guidance states that the licence conditions should not replicate offences. So you can't put a condition on that the premises licence holder should not employ people who do not have the right to work in this country. Suspension of the licence for up to 3 months could have an effect. However, at this moment in time, there is an illegal worker in March and then a illegal worker, although it's being contested. In July, that's 4 months apart. So there's very little to prevent issues from arising after a 3-month suspension. And that I believe revocation is necessary and proportionate in these circumstances. Thank you.
Thank you. Any questions from any panel member? No, I've just got 2 questions in relation to your report on page 38 of the documents. In the outcome sought, you've stated that the DPS and licence holder are the same person and have been complicit in the criminal activity at the premises. Can I just confirm that's in relation to the knife crime you're referring as criminal activity?
It covers for the knife crime. Effectively, the staff member has said that there's no training. He's received no training. It is an age-related product. It is a criminal offence. I would expect a responsible licence holder to provide adequate training to prevent such a sale from taking place.
Thank you. And further in relation to that paragraph 31, you state that the licence holder has shown acts of dishonesty towards officers. Could you just clarify what you mean by that, please?
For clarity on that one, he has not been dishonest towards myself. It relates to what Mr. Ward has put in his submissions regarding the CCTV that effectively he feels as though he was lied to when or immigration was lied to when investigating in March.
Thank you. Are there any questions from the police from the applicant or the immigration? Yes, sir. Thank you.
Yes, I do want to ask questions, but I need to just clarify a point with my client, if I may. You will see that the interpreter is sometimes commenting, but I've said if there's any questions, they should talk quietly amongst themselves just to do that. One moment, I just need to clarify a point.
We're just going to adjourn just for 2 moments. My colleague's just gone to the toilet, and obviously I don't want to miss it. If anyone else wishes to go, please do go and get yourself a toilet break.
Chair, we are still obviously in hearing, so please do not discuss obviously anything outside of this hearing.
Thank you. So, Mr. Dance, are you ready to ask questions?
Yes.
Thank you.
Thank you, officer. Perhaps I'll just take off where we ended. So, in relation to, you said that, is this your representation where you write at page 38, the DPS, the premise license holder, the same person have been complicit in the criminal activity at the premises? Is that your assertion in relation to the craft knife and the alleged no training? Is that what you were saying?
It is, yes, that is my report.
So, what evidence have you provided? Because I haven't seen it here. What evidence do you have that the premise license holder was involved with the seller engaging that unlawful activity, knowledge that he was aware of it and he was consenting to it together? So complicit. Well, where's the evidence that as the employer of an employee that he is complicit in it and therefore dishonest or a criminal?
As I advised to the chair, no training was offered to the staff members at that premises. They admitted that they had not been trained by the licence holder. Had they been trained by the licence holder, then the sale of the knife may not have gone ahead.
So you're only saying he's complicit because of the training, not because the knowledge of the actual sale. Is that what you're saying?
That's correct, yes.
So have you, obviously you've taken the word of the seller. Have you actually spoken to the DPS or interviewed him under PACE or even had a conversation informally and asked him what he understood to be before you come to a conclusion, before you put it in a statement and before you speak in public calling him a criminal? Have you given him an opportunity to respond before you made that conclusion in public?
I have not. Multiple members of staff have advised that they've not been trained, and my colleague had already spoken to the licence holder in January where he'd discussed the training verbatim to him, or verbally.
But the point is that you're innocent till proven guilty. You're a police constable. I'd take it you're a police constable. I don't know if you're a sergeant. I can't see your number. But so you haven't interviewed or questioned either via PACE or informally the premise license holder about training, but because of that, you draw that he is implicit in criminal activity at the premises. Don't you think that's an unfair assertion to make? Do you want to withdraw that now in public in fairness to him?
What I will say, Mr. Dadds, is that there is criminality at that premises and the licence holder is responsible for the overall control of that premises.
No, that's fine. That's different to being an employer, like the chief constable is responsible for officers that may become involved in criminality. It doesn't make him implicit in it. It means that he has the responsibility overall for his team. So the employer does have a responsibility for the premises and what goes on, of course. But here we're talking about the selling of the craft knife. Yes, or you call it the standing knife. We'll talk about the knife description later. But you're saying he's implicitly involved in criminal activity because he didn't give training. Are you prepared to withdraw that statement now and replace it with, I think he's responsible as the employer? They're two different things. And I think I'm giving you an opportunity to change that before. If you don't, then I'm going to be heavily critical of you because I think you're misleading the public and this committee.
That's what I will say, is that the business has traded irresponsibly by not providing training to the staff that has led to a sale of a knife to a child.
So in relation to alcohol, let's just go back one step. How many tests have there been, say, in the last year, or testing for the sale of alcohol to someone that's drunk or underage? How many tests has there been?
Could you just confirm the timescale then? Was it the last year?
Say the last year. Yeah.
The last year, there have been 3. 2 for knives, 1 for alcohol.
Thank you. And in relation, I'm just talking about alcohol at the moment because it's the alcohol license. So in relation to alcohol, there's been no alcohol offences that you're aware of that you're putting before the committee in relation to alcohol, is there?
I'm not aware of any offences under the Licensing Act.
And in relation to the knife, trading standards take the lead on that, and they've made the decision to give a warning as the appropriate step to the premise license holder with advice about what they should do in the future. Is that right?
It's a joint decision, so the operation is a collaboration between police and trading standards, so it's one that we would both have a say on.
So the police service and trading standards have both agreed that the proportionate and appropriate enforcement action is a warning letter, yes?
That is correct, yes.
And in assessing that, whether to give a warning, you would consider the culpability and harm as a result of the alleged offending, yes?
We would pick the most appropriate outcome for any such incident.
Now that was in, it's got lots of dates. So that happened in the 19th of May, is that right? And then it was subsequently tested again on the 16th of November, and they passed that test, and no other matters have arisen in relation to those since then. Is that right?
That's correct, yes.
So that matter has been resolved then, yes?
It has, yes.
And in relation to immigration, you don't make any representation because that's really for the Home Office. Is that right?
Very much so. All I have in terms of the immigration side of things is what I receive notification-wise from the other responsible authorities.
The last question around training, if I may. We know you've said already that you've not inquired about training of the premise license holder, but in relation to the craft knife or that age-restricted product, are you aware that there's any statutory obligation? Is there any? There's no breach of any law in relation to that, is there, that you're aware of?
Oh, could you just clarify that? I thought I did say that the sale of the knife was contrary to Section 141A of the Criminal Justice Act 1988.
Yes, officer. My question was around no training. That there's no offence in law regarding training regarding the sale of the knife, is there?
No, there is no offence in the training, but lack of training would be deemed irresponsible.
Well, it might be. If an offence is committed, obviously the lawyers here would give advice. But if there's an offence, an employer may be able to have due diligence, and part of due diligence would be to show that they've given training. That's the way of putting it, isn't it?
Yes, that would be correct.
So, in relation to the test purchase of the alcohol, that's a really positive step. You've got no other information before that there's any offence in relation to alcohol, so there's no sale of alcohol, no intelligence. You've got in relation to the retailing of alcohol, you've got no evidence that they're undermining the licensing objectives, have you? In relation to the sale of alcohol,
in relation to the sale of alcohol, yes. However, you don't just undermine the licensing objectives for licensing offences. It is the prevention of crime and disorder. It does not specifically say for licensing offences only.
Wow. Okay. Well, I'll deal with that in submissions, officer. That's incorrect. Is in a position of law, but I don't expect you to be the lawyer, so that's fine. I do have a question around language and tobacco, and that's really the last line of inquiry or questions, if I may, Chair. Fair enough to say that that they were in black bags. The tobacco, obviously secured because there's about £7,000 worth of tobacco. Is that right?
I don't know the value of the tobacco. There were 3 black bin bags on a table, just in a storeroom.
But when you say, but they were in a storeroom, secure, yes?
Correct, yes.
And they came back after testing to be lawful, genuine products.
That is correct after a preliminary undeterminable test by trading standards. They preliminarily tested it, they could not determine it and had to send it away to the manufacturers for testing.
Yeah, well, the thing is, trading standards looking at it are saying, I can't say either way. We'll have to send it to the manufacturer and they have ways of testing the product and we'll have to wait for them to tell us because they're the experts. It's their product. That's the normal course of a process, isn't it?
I wouldn't speak for trading standards, but I do know there are a number of ways that they can test, including visually examining it, checking other bits and pieces that they are trained to do.
Yes, and so what they were able to establish, in effect, they couldn't say it was illicit at the time. I mean, we might be going off track, but I want to just say it as a record. The duty stamp, the packaging, all that was inconclusive. They sent it away for testing. It came back from the manufacturers, all lawful products. None of it was counterfeit.
That is correct, as I mentioned in my representations.
Now, was there a misunderstanding in language? Because having spoken to the premise licence holder actually today when I arrived, when I asked him, what did you say to the officer? He said, I told him I have no invoice. And I said to him, but did you say anything more? I didn't want to lead him. He said, no. I said, he asked me, do you have an invoice? And I said, I have no invoice. Is that what you understand him to tell you?
I asked him specific questions around the invoice, where it had come from. All I could gain from him was a cash and carry in Aintree. That's all I could get.
Did you ask him for an invoice?
I did, yes.
And did he reply, he doesn't have an invoice?
Yes.
Did he say anything else?
Not that I recall.
Could I just, are we going down the tobacco line further? I think we've established the tobacco was legitimate and legal. Is there apologies?
Yes. Where I'm going is going to come very soon. It's officer. Did you ask him, if you don't have an invoice now on you, do you have an invoice at your office or do you have an invoice at the accountant? Did you explore what he meant by, no, I don't have an invoice?
I did not. However, I did speak to him on the phone afterwards, a couple of days later, I believe. At no point did he say to me, he's got an invoice. I even advised him that they were going away for further testing, and no such offer came to me that actually I have an invoice, here you go.
Yeah, yes, and that's exactly what he said to me. I said, well, did you offer the invoice? Because I then asked the question, well, you didn't have an invoice, but when you bought them, did you have an invoice? Yes. Where was the invoice? Oh, it was in the other office. Did you say that to the police? No. Why didn't you? Well, they said, do you have the invoice? And I didn't have the invoice, so I said no. Now, do you understand that that's a difficulty with language maybe between you and him?
Do get that. However, it was quite plain of, do you have an invoice? It wasn't a, do you have an invoice right here, right now? It is, do you have an invoice? Does one exist?
So you ask a simple question, you expect a simple answer, and maybe there's a misunderstanding in language.
Mr. Dadge, you are suggesting that there is a language barrier here, and perhaps if there's a language barrier, simple questions are the easiest option to communicate with someone where there's a language barrier. So asking a more complex question is going to confuse the gentleman more, is it not?
I'm not going to answer your question because I'm here to ask you questions, but I will make submissions later. The point I'm making will come out later why I'm pursuing this line of inquiry. So thank you. I have no further questions, sir.
Thank you. Just one follow-up question from myself. Officer, did you offer at any time an interpreter to the licence holder, and did he request any, or did you feel it was appropriate at any time for that?
I did not offer an interpreter. I was able to communicate with him in quite good English, in my opinion. I do not believe there was a particular strong language barrier, and no interpreter was requested.
Thank you. Okay, I'm now going to ask Mr. Dance to make representations on behalf of the licence holder. Thank you.
Right. Thank you, sir, member. Sorry, I've been sort of asking lots of questions. There's a few things to go through, but perhaps I'll do it in this way. In relation to the premises licence, it authorises the sale of alcohol. We all know that. And we all know, as a matter of fact, there are no offences being alleged to have committed under the Licensing Act. And in fact, one step even further, there's no offences, no breaches of conditions, the mandatory conditions. And further, it's been tested, the premises has been tested in relation to the sale of alcohol and has been successfully passed in relation to the refusal to a person underage. You've also heard from officers that despite having no conditions on the licence, they have a full working CCTV that's been shown and offered up. There's a refusal register, and it has challenged 25 posters and such on the premises. So, in fact, it's probably got more than some premises may have, or doing some things that people do have on their licenses and don't have. So that's positive, and I ask you to take that into account because it is important. The next issues that have been raised, I think, can be put into two categories. The first being illegal worker or workers, and the second in relation to the craft knife. Perhaps what I'll do is I'll deal with the craft knife now, and then I'll deal with the illegal workers. So in relation to the craft knife, I call it a craft knife. It is in effect what sometimes people will use with all sorts of work. It's not a Stanley blade. It is not a Stanley knife and not Stanley blade. I mean, I know that's a type of brand or product, but we all know what a Stanley blade looks like, and we know what a craft knife is like. And it is been accepted by the premises that an employee sold a craft knife to a child, and that should not have occurred. Now, it's not anything to do with licensing or the Licensing Act or the selling of alcohol. The Trading Standards Authority for this county, along with the police service, I'm looking at you and the police are there, so no disrespect, having regard to their powers to prosecute, enforce, took an appropriate and proportionate step to issue a warning. And that's the punishment to deal with that. And that was dealt with. It's the lowest level. I mean, they could have perhaps given an oral warning, but generally a written warning is the lowest form. So in relation to assessing, and I can see you're a magistrate, so you would look at culpability. So the statutory offence, you look at the culpability, then you look at harm, and you weigh up where that sits on the scale. Well, this doesn't even get off the mark of a caution. It's a written warning, and that's meant to have been resolved and dealt with. And I would respectfully say, members, that's the end of that. That has no bearing on the alcohol licence at all. There's no crime because it's not been prosecuted, because had they prosecuted, he could have raised the defence of due diligence. He didn't have to, because it was a warning. He says to Trading Standards, and he says to you now, that I advise staff that you mustn't sell knives and alcohol to anyone under 18. There's posters about Challenge 25. There's a refusal register. It's clear that it's an age-restricted product. Now, that being said, the council go back and say, well, we're going to test the warning, the advice we gave in November. And they did that. And the knife was refused to a 15-year-old. Refused. So that was showing that the guidance and advice was followed, and there was the refusal. Now, since then and now, there's been the review, and following advice, the premises has removed the craft knife for sale. So there's no sale of this product. I think there was a newspaper article recently saying knives. I think it gives a wrong impression of what has occurred. But certainly from a retailer, he's taken the view, actually, I'm not going to offer those craft knives. They will not be sold. They are not being sold. And I think that further demonstrates there's no further steps to take. In relation to somehow being, as the police said it, implicit in criminal activity, I think the officer did change his position. I'm not sure he has, but certainly if that was maintained, that would be completely inappropriate. It does not show complicit with criminal activity. There's no evidence of any evidence, and that submission is wrong and actually inappropriate. Furthermore, for the police to suggest the licence holder showed acts of dishonesty towards officers of the council, really the officer ought not to have put that in his statement. It really should be from what he has, and he has his knowledge. Of course, he can put hearsay in, but I think it's inappropriate. It's not only hearsay, it's third-hand hearsay. So it's what the officer told me of what he heard from a question of the immigration officer and the response given. I mean, it's completely inappropriate. And do you know what? That's gone in the local newspaper. And sales have gone down by over £1,000 in the week because of that has been gone into the press. Selling knives, implicit in illegal activity, dishonesty. It's serious words, and one's got to be really careful about what we say and do. And it's demonstrated by the Ofsted reports that people commit suicide, other people commit crimes. These are really serious. I mean, you may disagree with my comments here, but I know licensees that have taken their lives because of allegations and things being put in the press and social media. Responsible authorities, police officers and others have a duty to make sure when they are making statements and making comments that they are correct and that there are sometimes consequences and effect. So I would say that is inappropriate, not appropriate in relation to the knife. And what the officer is saying, he's only commenting in relation to the knife. He's saying the training and the sale means that it's implicit. And I would ask you to find that that's not the case here. And that's not correct. But anyway, I don't want to overplay that position because, as I've said, I think the officers rowed back from that. We've had the discussion about what Trading Standards thought. They are not party to the review. I think you have no regard to what the police say in relation to, well, they've not joined because I've done it. Well, no, actually, Trading Standards as a responsible authority are not party to the proceedings. They've raised no representation. They've dealt with the concern that they had by way of a warning, and they have not sought the review. Moreover, the police didn't seek the review at all. So the police could have, if they wanted to, following May, sought a review. They didn't. and obviously they've joined the review, and I think that slightly changes the position. Now, the matter that is left to cover is the matter about illegal working. It is unusual. It's not, doesn't mean it doesn't happen, but it is unusual, certainly now, because the Home Office or the Border Agency, I always get confused which one, has the power to call a review. And that they, since then, they ordinarily would bring a review for immigration offences or civil penalty offences. It is unusual for the licensing authority to bring it. In fact, I can't recall a licensing authority bringing a review for an immigration matter. I'm not saying that they can't, because of course they can. But as you saw, when I start asking questions, the officer says, well, you're going to need to speak to the immigration about that. And that's the difficulty. The immigration officer, no disrespect to him, doesn't know the difference between a civil penalty and a fine. And so I will just explain briefly, no criticism, because it's not his fault if his employer has not given him the necessary training or knowledge. The reality of it is that if there's an offence under the immigration, i.e. you are restricted from working or you have a restriction, you commit an immigration offence and you can be prosecuted, i.e. the person working. Or if you are found as an employer, say, for example, contracting with someone for work, you commit an offence. Now, you have to have, part of the ingredients for an offence, you have to have knowledge, knowingly employing someone that is not entitled to work. Now, here we don't have a prosecution, and either the Immigration Service have determined they're not going to prosecute. So therefore, there is no crime, but insofar as there's been no conviction. Now, your legal advisor said, well, hang on a minute, that means we don't have to, we can hear it before waiting for a prosecution. That's right. But here there is going to be no prosecution because a civil penalty has been issued on both. So therefore, we don't have to wait. We know the outcome. The outcome is there's no prosecution, and as a result, there's no crime. But what we do know is that the Home Office have determined through the civil penalty team have decided to issue a civil penalty. A civil penalty is not a fine. You know the difference as a magistrate, but it is difficult sometimes to explain to members the difference. Some members will tell me, last time I did this argument, they said, it's all the same. But in the end, they decided, actually, we understand there is a difference. The fine is because you've committed a criminal act and you've been prosecuted and you've been found guilty. A civil penalty is not the same. It's a civil standard, but also the civil penalty is given because you didn't do the right to work checks. So as you didn't follow a process, and the employer has an obligation to do checks before employing someone. And if they don't follow those checks, they can give a civil penalty. Now, you can appeal a civil penalty by saying, it didn't happen, I'm not contracting that person, I've followed certain steps, these are the documents I asked for, I'm cooperating with you. There's a number of matters, but it's because you didn't follow a process. It doesn't mean you're a criminal. It doesn't mean that you're a criminal. It means actually as an employer, you failed to take certain steps to ensure that person, whether they have the right to work. Because, believe it or not, some people do tell employers they do have the right to work and that they have documents. So I'm going to deal with now the two matters arising. So January and the July. So the March matter. So in March, there was an individual at the premises who did not have the right to work. Now, that individual was the same individual there in January. Now, in January, just so it's absolutely clear, another worker at the premises who is entitled to work has a friend. This is the friend. He wants to seek and get employment, and he's, in effect, visiting his friend. And he visits his friend often in January, and he's asking for work. The premise license holder offers him work towards the end of January, early February, on the basis that he believes that he's entitled to work, understands that he was working somewhere else previously, and asked him for his documents and his passport, etc., for the PAYE. He employs 15 members of staff through the various shops, and he's never had a matter arising, as I understand it, and there's been no other penalty arising at this premises. So this is the first penalty, as we understand it, at this premises. So he engages him. He's waiting for the documents. The police come in January. He knows the police have come in, and the police are asking questions about the right to work, and he's saying, I've asked for the documents. So he's aware, the police in January, that he's aware that there's been questions asked about, the right to work. He's saying, well, I'm getting the documents. I'm employing. He has CCTV, which he keeps. And then when they come, and the police officer, having the concerns, I think it's probably been a bit sort of overplayed, but the police officer says to you today, his colleague had concerns. And I don't know how high that is in the sense of the concerns, because if I had a concern, and members, if you had a concern as a police officer, so imagine this scenario, if I can just have your attention for a moment on this point. If you were putting in an application, or if you were the police officer, knowing that I've just put an application to be the DPS, if you think, oh, hang a minute, there might be an illegal worker on the premises, before you prove the DPS form, wouldn't you make some further inquiries, even say to the premise license holder, maybe send an email? I encountered 2 people on your premises. One seemed to be evasive, although we don't have any records of that. Can you tell me, are you satisfied that they have the right to work? None of that, that's not come from the police. That's not come from the licensing department. No one's followed a graduated approach to enforcement. I'm not saying, and please, I'll make it absolutely clear, the responsibility is for the employer. But likewise, with the council coming here today saying, oh, well, we had concerns. Well, you could have sent a letter to the premise license holder saying, well, these are the concerns we have. Can you double check, please? That would be the normal course of process. And then had you sent that and there was a subsequent finding and another subsequent finding, then I think they might be justified to come along and start saying, could you consider revocation? But if you haven't gone through a graduated approach, I think it's a bit disproportionate. Now, in relation to the individual then in March, they come along and there's no surprises, the individual's there because they're known that he's there. They look at the CCTV and we say that there's a misunderstanding in language. They was asked, do you have the CCTV? He says, I said to them, we have CCTV. I don't know if it's working because he's only just moved in. And he says he was showing them or pointed to them where the CCTV was at. It was not a position that it was found and discovered. We don't accept that submission. Now, I've said there might be a problem with language because I'm not suggesting that the officer is lying. I'm not even saying that officers doing a half truth. I genuinely believe there might be a misunderstanding on both. And the reason why I've come to that conclusion, because my client is sure that he told them that he wasn't sure whether it was working. But in relation to tobacco, I know I went around the houses with the tobacco, but he told me today, I told him I had no invoice. What he meant, he had no invoice on him. Yes, he had the invoice. And I said, had you asked, given the invoice later? Well, did they ask for it? Did you offer it? No one asked. And I didn't say anything, he says, through the interpreter. But he said, I got it from the cash and carry. I told them I bought it from the cash and carry. It was bought from the cash and carry. It was in the store. He said, but when the officer asked me, have you got the invoice? I said to him, no, I don't. Because he thought it meant then and there. There's clearly language is an issue. And I think to say outright that he has lied to the officers about the CCTV, I would say there is a misunderstanding. He has not lied. He says, and I don't know where it takes us, but I want to make sure you understand. He says, I don't know if it's working, because they asked, is the CCTV working? And because he's only just got to it's moved over, he's saying, I don't know if it's working. But it was working. So in relation to the matter for January, after assisting the Immigration Service and being the first offence, they issue a penalty, reduce it from 20 to 10, and he pays within a certain time period. I think it was within the month, and therefore he was entitled to a further credit, and it was then reduced to £7,000, Chair. And so therefore, in relation to the civil penalty, he has in effect received a financial penalty, and that acts as a deterrent for him to make sure in future, and he was told by the Immigration Service, always get the documents first before they start work. Don't believe them if they tell you they're entitled to work. Don't wait for the documents. Make sure you secure the documents before you employ them. And that's in relation to January. So in relation to that, that was the position. And that was, March, but it's nearly a year. And after that, there were no review, no further matters being complained of. And certainly the licensing authority hadn't written to him about any of those concerns. Then we moved to July. So I'll give you time if you want to, if there's any, do you want me to pause for a minute or no? In relation to July, we put it very simply. There are no offences. No offences under the Immigration Act, and the civil penalty, whilst being issued, has been appealed and it's not been accepted. So there is no finding of either of any conclusion at the moment because it's going through a process. What we say is that the two individuals that were in the storeroom area are family members. One's a cousin and one's a nephew. And they were talking to the premise license holder in the store. Actually, I think it was the nephew walking to the store. He wasn't leaving the premises. But let's just make it absolutely clear. It's not a big premises. There's one worker on the till. The premise license holder in the premises. They're the two working. Doesn't need more. Actually, it needs one or two individuals there. The other two had come to visit, and they told the officers they had come to visit. The officers had seen the CCTV, and as I understand from viewing the CCTV of that, they did not see them working, but they believed that they had seen him, one of the individuals, helping the premise license holder on another day and therefore issued a penalty. Now, helping your family member is not employing illegal worker. It isn't. There's no bar to that whatsoever. And on this day, which is alleged to have occurred, they were visiting. They sometimes visit and they eat. And they do visit, and he is there. And there's nothing to prevent them from doing that. And the CCTV, we say, showed at the time when they looked that there was no work or working. But in any event, the law says, in relation to working, an illegal worker, a person working is that person working under a contract of employment, under a contract of apprenticeship, under a contract of personal to do work, under for the purpose of contracting services, a number of other things that are not relevant to today. Neither of these two individuals were working. The individual that's subject to, that helped out on another day, that was seen on the CCTV, that individual is a senior carer and has a full-time job in a nursing home and works between 40 and 50 hours a week. And that's their full-time employment. They've been told that by the solicitor acting for that individual, because that individual was detained for a month, then released, and proceedings are currently being dealt with at the High Court by judicial review, because they're saying that they, in effect, took action to detain him and withdraw his rights without going through a proper process and asking the appropriate questions and making inquiries. That's for another call. But the point being made here, we say absolutely, and you've got no evidence contrary to it, that they are family members, weren't working, not under contract of employment, in the storeroom, talking to the premise licence holder, which is entitled to do. It's an appeal. Subject to that appeal, no conclusion's been made yet. So we say you can't make any findings of fact in relation to that. And we don't say that there's any matters relating to the Licensing Act in relation to that. Now, the officer from licensing, earlier on in the start of the submissions, Just me 1 minute. Apologise, bear with me. Said that that this was the second time in July, multiple, no due diligence, no right to work a second time, unacceptable the second time, disregard to the law, fined, wasn't only aware last week of the appeal, and said because of that second time and because of the disregard should revoke the licence. And I say that that submission and that recommendation is based on all on the July, which is incorrect for the reasons I've just submitted. It's subject to, now obviously it's subject to an appeal. If the appeal finds something different, then obviously that officer can come back. But we would respectfully submit. Yes.
Apologies, you're in the middle of your submission. Would you mind a 5-minute adjournment, please? Thank you. If anybody wishes to leave the room and nip out for the toilet or a drink, please do, but obviously please don't speak to each other. Thank you. Right, thank you for that, everybody. Mr. Dance, I do apologise once again for interrupting you, but please feel free to continue.
No apologies needed. I'm almost there. You'll be pleased to hear. I think the immigration matters for the July, because they're subject still to the process and appeal. There's no affirmative on the civil penalty or the appeal process, and you've heard the submissions about what we say, and we say there's no illegal working. Now, I just want to address you on guidance on the law, if I may. And obviously, you're an experienced member, so I hope you don't mind. You will have heard this before, but I just want to, just for fullness, make sure that it is said. We are here, you are here, we're all here for the promotion of the 4 licensing objectives, and that any decision you make must be appropriate and proportionate to achieve those licensing objectives. So, for example, on having heard from me and the submissions, you believe that the selling of alcohol, the licensable activities, will not be undermined going forward, then you take no steps. It may be that you put conditions in place. It could be that you suspend the licence as a means of deterring the premise licence holder from the mischief that you identify as occurred as an appropriate step, and that or revocation. Now, in relation to that, the statutory guidance is really clear that you look at each case on its own merits, and that in relation to what you can do and what you do is look at the cause or causes of concern and only do what is appropriate and proportionate to achieve the licensing objectives. Now, if you bear me 1 minute, because this is just a new addition for this year, so I just need to remind myself of the paragraph. It's just moved over the other page. Sorry. In deciding what powers to evoke at 1120, it's expected the licensing authority should, so far as possible, to establish the cause or cause of concerns that the representations identify. The remedial action should be taken should generally be directed at those causes and should be always no more than the appropriate and proportionate response to address the concerns that instigated the review. Now, I do take issue, only a small issue, but I take issue with the applicant's reading of 1123 earlier on, because it was, I think, taken out of context, because you only had the issue of where premises are found to be trading irresponsibly, but there's a few paragraphs before. I'd like to read it in full. Licensing authorities should also note the modifications of conditions and exclusions of licensable activity may be imposed either permanently or temporarily up to 3 months. Temporary changes or suspensions of up to 3 months could impact on the business holding the licence financially, would only be expected to pursue in an appropriate means to promote the licensing objectives or preventing illegal working. So, for instance, a licence could be suspended for a weekend as deterring the licence holder from allowing the problems that gave rise to the review again. That's really important, members, because if you think that, well, actually, the concern in January, if it needs further steps, although I don't think, sorry, I keep on saying January, it's actually March. If you think additional steps are required, then you could impose a short period of suspension to deter. But given it's nearly 10 months ago and the licensing objectives haven't been upheld and there's been no issues arising with the selling of alcohol, you may not think it's appropriate. But if you do, then it says here, well, you could suspend for a weekend as a mean to deterring. Now, suspension is quite a draconian step because they'll lose revenue, and it's like almost a means to a sanction. Yes, and it does act as does act as a deterrent, so a sanction. To suggest, I think someone suggested, well, just suspending you just get the same operator afterwards. Well, no, absolutely not. I would say that a suspension is there by an Act of Parliament as a part of the statutory scheme to give a warning. It's no different if you do the Hackney carriage or whether you do taxi drivers. You may suspend them for a short period of time with the hope that that will deter them from matters arising again in relation to mischief. It then goes on, however, it will always be important that any financial impact that may result from a licensing authority decision is appropriate and proportionate to promoting the licensing objectives and for preventing illegal working in the premises. So, you need to look at proportionality. Suspending someone for 4 weeks, 6 weeks, or 2 months, 3 months has a huge impact on the viability of the premises. It's not only affecting the premises, but it's affecting workers, the viability of a business, and it's like a sledgehammer to crack a nut. So if you are considering suspension, then it needs to be proportionate to the harm, the culpability, all these things to make sure it's a balanced decision, a proportionate decision. Please bear in mind, and this is a very important point, no member of the public raised any representations during the 28 days. No councillor raised any objection to the 28 days. And that's important to know. This shop does provide a service to the local community. And we know that all the taxes are paid on the duty on the alcohol, taxes are paid on tobacco, all the tobacco is correctly in place. This premises has been tested for the alcohol, tobacco, and for underage sale. No licensing offences, promoting the licensing objectives, we say. Then, in relation to the statutory guidance, it says even at first instance should be seriously considered when you're looking at the range of the steps. Now, I dealt with the East Lindsey District Council matter, where on that occasion there was revocation of the licence, but each case is on its own merits. This was that case derives out of 5 times the person had been caught with illegal workers. The individual had paid someone to come in through trafficking, was sleeping within the restaurant, no rights, no payment. I mean, it was a very hard case. And in that case, revocation was made. And I dealt with that on behalf of the local authority. Here, we're not talking about that at all. And I think we need to get things into perspective. So there was no review after the matter arising in March. I would say that the reason why the licensing authority has made the application now was the matter in July, and that's premature because that has not concluded. And so following the law and the guidance, I'd ask and propose this question in my submission, and I won't repeat it in closing, is that members, can you be confident that the issue regarding the knife or the craft knife, will that be sold again? No, because they're removed. Can you be confident that there'll be the right to work checks carried out? Yes, and they have been going forward. Are you satisfied there will be no underage sale? Well, you can be satisfied because there's not been any in the past. Can you be satisfied there've been no licensing offences? Yes, there's no evidence of any in the past. And on that basis, I would submit that going forward, the licensing objectives will be promoted. I would suggest this as a way of dealing with it. I do think that we would be content and satisfied for a standard condition regarding training, standard condition regarding CCTV, its retention for 31 days, a refusal register. I would say the very worst position would be is to remove the DPS and have a dedicated DPS for that site, although I don't think that is necessary. So unless I can assist you further, and I'm happy to answer any questions, those are the submissions on behalf of the premise licence holder.
Thank you for your comments. Do we have any questions from any member on the panel? No? I've just got a couple of questions. Could I ask, how long has your client held a personal licence, please?
Um, 20 years.
Fantastic. And in that time, obviously, he'll have employed a number of staff. He currently employs 15 from what you stated. How many members of staff? I'm conscious you won't have a figure, but roughly how many members of staff have he employed in those 20 years?
I think that will probably be a difficult question, but what he can say is that this is the first offence, and he's had, obviously he didn't have 4 shops, he has 4 shops now, but he's built up his business as employed, and understands and assures the committee before anyone commences any work, the right to work checks are carried out. He's also got himself a licensing agent come interpreter for Tamil, for his own language, so that he's being supported. Also, we have a product which is coming very soon, which is in his own language too, called Licensing Connect, which is translated into Tamil. So, but coming back to your question, multiple people over that time, and this is the first matters arising.
Thank you. My next question is, has he had any additional training in relation to employment checks following these incidents?
Yes, he has. He's got the links to the checklist and the checks he needs to make, and also the licensing agent in his own language has gone through that. He does know the licensing objectives, knows the checks he needs to make. He was unaware, but I went to the premises this morning before coming here. I checked that there was the refusal register was at the premises, that there was the Challenge 25 posters, and that the CCTV was present. So I did that without hand just to check that they were all in order, and I can say to you today that they were all there in order.
Thank you. My last question. During the submission, you stated, obviously, the July case is at the High Court. I noticed there's nothing being submitted in evidence to support that, and I'm not for 1 minute doubting that. Do you have any evidence to show that that case is currently at the High Court and not concluded?
I have. I can only make submissions in regard to the appeal of the civil penalty, but that's been confirmed. And I do have a document from the solicitors that are dealing with the High Court matter, and receipt of that. It was issued from the Royal Courts of Justice on the 7th of December. Obviously, I'm an officer of the court, so I can say that there is an application that's been lodged, and I can give you the case reference. I have read the submissions from the solicitors acting, so there are documents at the High Court, and I've read them.
Thank you. Are the responsible authorities happy and content with that? Yep, thank you. I've got no further questions. Mr. Ward, do you have any questions?
Yeah, just a couple, Chair, please. I attended the premises on the 9th of May, and the gentleman in question, which I referred through to the Immigration Service myself, seemed to be in the premises on his own at the time. Do you understand why he was in the premises at the time? Was he working in the premises? You said he was his cousin who was visiting, but that is the same person as when I visited the premises in May. What was he doing in that premises at that time?
Yes, so in relation to that, my instructions are that on both occasions. Well, so on the first occasion, when he visits, he comes and visits. They break bread together, they eat, and he is a cousin. He has a full-time job as a carer, and often he comes in and socialises with his family member. So on both occasions, he is not a worker. He visits. It's no different, with the greatest respect, that within the Sri Lankan community, they don't socialise generally out and about. They socialise with each other, and normally at their place of work as well. They might eat food or whatever, and that's what he has given me instructions of what happened on both of those occasions. And there were other occasions when they visited, when he has visited, and they eat together or have tea after work. That's what I took as instructions. Is that correct?
Yeah, that's fine.
Yes, he's just confirmed that that's correct.
So when I visited the premises on the 9th, why was he behind the counter at that time? And I said the 9th, sorry, on the 9th. I've not said the other night. I said on the 9th May, as in the supplementary agenda that was shared around. So on the 9th of May, when I visited the premises, before the referral was made through to the immigration service, the gentleman, when I first entered the premises, was behind the counter serving people. So
what he says to that, he's not a worker. He sometimes helps him out, and he's at the premises, but he's not an employee. To be an employee, you can have a family member help you out. And
that's fine.
And let me just clarify. He was preparing food and he was helping out. So there was another worker also in the premises, or due to come to the premises 30 minutes later.
Yeah, so
is that correct?
My follow-up question to that, if you're okay for me. So the follow-up question to that is, why were you unavailable at that time, and why did it take the other worker 35 minutes to attend the premises when asked for another member of staff?
The other person was due in 30 minutes, and so is he.
Okay, so it's even though he wasn't a worker, he was left in the premises on his own, and for that 35 minutes, he was in control of that premises at that time.
No, I think you've misunderstood. He is a family member. He can help him out, but that to be a illegal worker, you have to show that there is a contract of employment and a payment for work. There is no contract in that regard. He has a right to be in the United Kingdom working as in a particular area, which he's a carer. He has a full-time job. Let me just answer that so that we're absolutely clear on it. So he works for Dual Home Support. He has worked on a permanent basis as a senior carer. He has worked at that company, Dual Home Support Lancashire Limited, since the 16th of February 2023. They say, we understand that the Home Office have detained him on the assumption he's been working or employed elsewhere. According to our knowledge, he has only been working in this organisation full time. He has been completing his allocated rota, and he's covering 48 to 55 hours per week in Dual Home Support Lancashire, and given his date of birth. Now, so he has got his own job, his own full-time, he's a family member, he's a cousin, and he does pop in and has helped out, but he's not a worker, he's not employed under a contract.
If that's the case, why were we advised that he does 2 hours per day and 20 hours per week at the premises?
Well, that's not correct, and that will be subject to the appeal, which is ongoing, and the High Court proceedings.
Any questions from any responsible authority? Yep, thank you.
Thank you, Chair. Mr. Dadds, just wanted to clarify just around the dates. Initially, you've mentioned March with my colleague, and then you jumped to January, and then you was talking about my colleague doing right to work checks. Is that lost in translation, that you just got confused with the dates? Because my colleague didn't do any rights to work checks. My colleague in January simply made a referral to the immigration services, just reporting some concerns. Could we just clarify that?
Yes, thank you. Sorry, I apologise for confusing the January and March dates. So to be clear, obviously in January there was a visit on the 9th and a revisit on the 10th of January. You said in your submission that your colleague had some concerns, and so she made a report to the immigration service. I say in the submissions, and I think in some of your answers, there was never at any time a phone call or a written note, a letter following a graduated approach to enforcement to the premise licence holder saying, I think we have some concerns. You've been told, or you may believe that this person has the right to work, but have you checked? And that's what I was mentioning in January, because as a consequence of the referral, the Home Office then went, I think, on the 11th of March. Let me just check the date so I've got it right. I apologise, all these dates. Yes, on the 11th of March, then visited as a consequence of the information provided by the officer visit on the 9th of January. And what I'm saying is that if part of a working in partnership and together, if the police service or licensing believe that the premise licence holder may be employing someone illegally or not correctly, then there should be advice given, because the civil penalty process is about not doing the right checks, checking that the person has the right to work, and if an officer believes that there are concerns, like you did with the tobacco, you would take that tobacco. If you've got concerns with the workers, you could raise it in advance, and it wasn't raised in advance. Now, I'm not criticising you or your colleague, because ultimately the responsibility is the premise licence holder, but I'm just raising the point that it was never done by the police. It could have been done, and I think good practice would mean that it should be done. If you've got the concern, you raise it, you speak to the premise licence holder, because the police standard, sorry, I'm trying to get the right word. I think it's the through the police college have a process of the route maps. And it says that if you identify a problem with a premises, good practice is to call a meeting, share your concerns, make a note of it, and share that information. So it ought to have been shared. Also, the concern could have been raised, or should have been raised, with the premise licence holder. I encountered these two people. I think one of them you may need to check whether they have the right to work. So that's to do with January. Obviously, the July matter, we're saying they're not employees, they're not workers. That's the position.
Thank you very much. I just wanted to clarify, because it did sound initially that you thought my colleague had done some right to work checks, which wasn't the case. My next question, and great to hear that there's a refusal register in the premises as of this morning. We've established during this hearing, obviously the licence holder has limited spoken English. What is his written English like, and that of the staff? Could they maintain that register?
Well, firstly, can I correct you? An officer has been, I think, on the 10th of January of last year, and saw a refusal register. So there has been a refusal register previously. I went this morning to check that there was a refusal register, because I knew that the refusal register would be coming, and I've got it here. But there was also a refusal register in the premises this morning, obviously because I wanted to make sure if we've got this, there was still another. And it is being completed correctly. I've checked it. It's clear to read. In fact, it has tobacco or vapes predominantly are being refused, and energy drinks, a scratch card, It has a number of matters being recorded, and I think it's clear. So there is a refusal of vape products, lottery, and alcohol. So they are challenging, and the book is being completed.
Thank you very much for that. Just for clarity, obviously you mentioned that my colleague last January saw a refusals register. The report my colleagues wrote up wasn't that they saw a refusal register. They spoke about refusal register and they spoke about training. There was no physical documents seen.
That's fine. And just to emphasise this point, there has been a local agent been assisting this premises, and that local agent has been helping in Liverpool, but this gentleman sits to my right knows licensing inside out. I've known this gentleman for many, many years, and as a licensee himself, and speaks the language, and as a licensing agent, and will be giving and has given training in his own language too. So I think that's only positive going forward to ensure that there's no misunderstanding. Languages has been an issue insofar as when the officers have attended, but now they will get assisted because there will be an interpreter can pick up the phone. There's not a problem with language with the members of staff and customers in challenging, asking for ID. I think when an authority figure attends, there is sometimes that cultural reaction, and sometimes I think they freeze up a little bit, and I think it becomes then problematic, not because of any blame or fault. I think it's just authority come the cultural side of the Sri Lankan community in relation to Tamil.
Thank you very much. No further questions, Chair.
That's brilliant. Thank you. Okay, we're now at the stage for summing up. I will please ask the applicant, Mr. Ward, to sum up on behalf of the licensing authority. Thank you.
Thanks, Chair. In summing up, basically back to my comments of before, panel, we asked you today, are you happy now? Can the risk of further immigration crime specifically be mitigated by proposed conditions placed on the licence? Would the licence holder still adhere to them? In referral to the guidance which we must follow, it's 1123 still states, where the premises are found to be trading irresponsibly, licensing authorities should not hesitate, where appropriate to do so, take tough action and tackle the problems that are before you. Wherever measures are deemed insufficient to revoke the licence. As per the offence of employing a legal person, there is certain criminal activity that may arise in connection with the licence, which should be treated particularly seriously. These are the use of the premises for employing a person who is disqualified from work for the reasons of their immigration status in the UK. It's up to committee now to decide which action they would take against the premises, and I would finish summarizing there. Thank you.
Thank you. I'll now ask the immigration officer to please sum up.
Yeah, I fully support everything that licensing has said. We obviously have encountered one legal worker back in March for which a fine has been paid. We do suspect that two further legal workers were there in July, one of which was also encountered in May. So we do believe that they would be willing to employ legal workers going forward.
Thank you. And finally, the police to sum up before we go to Mr. Dance.
Thank you, Chair. Much like Mr. Ward, I'd just like to go back to the Section 182 guidance, in particular 11.24, and it says that a number of reviews may arise in connection to crime that's not directly connected to the licensable activity. In this case, we, as a constabulary, have had the sale of a knife to a child or a bladed article. For example, it then explains matters arising because of drug problems, other bits and pieces. None of that rest of that sentence paragraph is particularly relevant because it does start to talk about matters that are not connected to that premises. But it's the last sentence that I would like to read out, and it's the licensing authority's role when determining such a review is not therefore to establish the guilt or innocence of any individuals, but to ensure the promotion and licensing objectives of, apologies, I'll read that again, but to ensure the promotion of the crime prevention objectives. Mr. Dadds has said in part of his representations that the crime prevention objectives hasn't been undermined because there has been no prosecution by any authority. I would refer you to a document published by the Home Office in partnership with the Institute of Licensing. For clarity, it is an archived document in November 2016, but it details the stepped approach. In that document, it clearly outlines a pyramid diagram, and it outlines all that various information. I've got it here somewhere. I'll read it off my phone.
I don't want to stop the officer. If he wants to talk about the principle of that document, I remember it. It's very old. I don't have any objections to that. But laying the new information now on a document that he wants to rely on, which is not, it's advice by, I think it was Lakehorse originally, and then the Institute of Licensing. But to do it in the conclusion would be wrong. The conclusion should be of all the information that has been presented during the hearing.
Thank you, Mr. Dadds. Officer, could I ask you to sum up with the information you've presented and not present any new information? Thank you.
Fine, I will end there. Thank you.
Thank you. Mr. Dadds.
Yes, I will be very brief because I think I did my summing up last time. But in relation to the licensing objectives, can you be confident that they will be promoted going forward? In relation to the right to work checks, I've explained what happened in January, July is to be concluded, but you could place a condition on the licence that says that all right to work checks should be carried out beforehand, a record kept for inspection by the licensing authority and licensing police. I've also offered the condition regarding CCTV refusal, retention and training. And in relation to, my submission is that you can be satisfied the licensing objective will be promoted. In relation to the bladed article, the craft knife, I believe you can be satisfied the licensing objective will be promoted because they're no longer on for sale. But I don't, with great submission, I don't think they have a nexus with the Licensing Act per se. In relation to the license itself, which is the license for activity, the sale of alcohol, you've heard that there's been no breach of condition, no sale to alcohol to anyone intoxicated, anyone underage, and in fact it's been tested for underage sale and it's been refused. You've also heard there's a refusal register, CCTV and challenge 25 at the premises. So can you be confident going forward? I would respectfully submit you can. If you're not with me, I would say the very harshest sanction you could impose would be a very short period of suspension to avoid the mischief that occurred in January. The warning letter has already been given in relation to knife and bladed article, i.e. the craft knife. Don't believe it will be appropriate or proportionate to sanction again. And there's already been harm in relation to the way that this case has been reported, notwithstanding that. And there's already been a sanction of £7,000 which has been paid. So I would ask about totality, proportionality. But certainly in relation to the licensing objectives, there's been no offences in relation to the selling of the alcohol. And we say going forward, the right to work checks are being done and will be done. And there's no prospect of a craft knife being sold, as we don't sell them anymore. Unless I can assist you further, those are submissions on behalf of the premise licence holder.
Thank you. Can I just ask our solicitor if there are any other matters to be raised or resolved before the hearing's closed? Thank you.
Mr. Dadds, I just have one point of clarification, if I may, and it may be that I've misheard, but it was around the July events and the two individuals that were obviously subject to immigration checks. So I recall you mentioned about one of them being the senior carer who was working between 40 to 50 hours. And that individual was detained. And is it that individual that has now appealed to the High Court, or is it the judicial review element that you're referring to? Can I just get clarification on that? Because it wasn't very clear to me.
As I understand it, and I'm happy to be corrected from the officer if need be, but as I understand, there are two people encountered, one a cousin, one a nephew. They're connected. The nephew, there's been no penalty issued for that individual. But there's been a penalty issued for the other person, who is the carer who was seen previously working on the CCTV, as I understand it. And that individual was detained, then released, and that's subject to the High Court judicial review proceedings, and the premises separately are appealing. That is my understanding on my instructions. So that's how that is working.
So it's the same individual that is subject to the penalty aspect and the judicial review?
No, the judicial review is the individual himself, and the penalty is the premise licence holder who is appealing. So there's two matters ongoing.
Thank you.
Thank you. Do we have any final legal points to be raised by the Borough Solicitor? Thank you.
No, thank you, Chair.
Thank you. So we've heard from all parties. The panel are now going to go into deliberation. As I stated at the beginning of the meeting, I don't know how long that deliberation is going to take, but if can I get an indication from parties if they wish to stay, obviously not in the room, but stay to receive the result after the deliberation, or whether they would like to receive a phone call followed by a full decision notice within 5 days. Do you wish to stay, or do you wish to receive a phone call? Thank you.
Could I give an indication for us? Obviously, we're in your hands, but we certainly are happy to remain till 4:30ish, and if it's longer than that, we'll probably ask to be excused, because I think it will take you 5.5 hours, and I think it's taking me about 4.5 hours to get home. But obviously, we'll remain for a little while, nearly to an hour, and see how we get on, if that's all right with you.
Yeah, just before you leave the room for deliberations, could you pass details of telephone numbers, etc., to our democratic service? Is that okay? Yourselves, again, obviously, if you want to stay behind, it's entirely up to yourselves. What I will do then, did you say you're happy to wait for up to an hour? Okay, what I'll do then, it's now 3:45. We'll call back in at 5:45 and give you an update of whether we've made a decision. We may call you in before with a decision, but if not, we'll resume at 5:45 with a quick 2 minutes of where we're at. Is that okay? And then we'll go from there. Okay, thank you. If I can ask everybody